for the Labor Day
Government by executive order. Is it a good idea? Obviously not. If we wanted to have a king, they would have set up that form of government. George Washington was basically offered the chance, and even when he took the presidency, he refused to stay there beyond 2 terms. He said, that's enough. We need to spread out our government into different chambers, checks and balances. Remember that beautiful term, how important that was? Executive orders fly in the face of that. Our guest to discuss it, Mark Chenoweth, Senior Attorney and Executive Director of New Civil Liberty Alliance and former Chief of Staff to Congressman Mike Pompeo. Mark, what is Pompeo up to now?
Well, I haven't talked to him in a couple of months. I think he's probably resting up from a long stint as Secretary of State.
He was in my fair city, Houston, last week, doing a fundraiser for Sarah Huckabee Sanders. And so I know he is staying politically active and sure making himself look like a future presidential candidate.
Well, I guess I wouldn't be shocked if that were to happen, but I have not heard anything official.
Let's talk about New Civil Liberties Alliance. What exactly y'all do?
Sure. NCLA is a nonpartisan, nonprofit organization that protects people's civil liberties from the administrative state. So we have both clients who have been the targets of enforcement proceedings where their due process has been denied, for example. We also represent folks who are going on the offense against some of these administrative agencies who are engaged in all sorts of antics, and we're trying to take away tools and tactics from the administrative state that they use to violate everyone's civil liberties.
When people hear the term civil liberties, I went to law school, you went to law school, and they may not know what that means. What is a civil liberty? What does this term mean?
Well, a lot of times what we're talking about are the specific civil liberties that are spelled out in the Bill of Rights. So, for example, we're talking about the freedom of speech. We're talking about the due process of law. We're talking about the right to trial by jury. Folks may not realize this, but if you are brought in front of an administrative law judge in an administrative hearing, your livelihood could be at stake. You could be subject to hundreds of thousands, if not $1 million fines, and yet there's no right to trial by jury in front of an administrative law judge. And we think at NCLA that flies in the face of the Bill of Rights, and we're trying to push back against what the administrative law judges do. And there's lots of other ways that they violate folks' civil liberties as well. It also includes your Fourth Amendment search and seizure rights. Folks are accustomed to the idea that if the police want to see your inside of your car or inside of your home, they have to have a warrant in order to do that, or they have to have your consent. Administrative agencies oftentimes try to proceed without a warrant, without consent, without probable cause of any kind. They just issue you some sort of an information request, and they expect that you will follow it, and that if you don't, you're going to be subject to a fine. And again, we think the Fourth Amendment has something to say about that.
You know, the Fourth Amendment was described to me by my crim law professor, Michael Tiger, as the most important amendment that nobody's ever heard of. And it's interesting to me how many times in law school and since I found myself saying, that's a Fourth Amendment or Fifth Amendment, but more often Fourth Amendment violation. And the sort of thing, you know, everybody knows what the First Amendment is, everybody knows what the Second Amendment is, but how often the Fourth Amendment comes up as something that is the basis upon which to challenge unconstitutional governmental action is shocking to me. It's surprising to me. It's incredibly important.
Well, and the other place where it comes up that we're pushing back right now is in this area of automatic license plate readers. You may have seen these. I don't know if you have them in your community, yep, Michael, or not, but we have a lawsuit against Coral Gables, Florida, right now because the city there has put ALPRs at every major intersection in the city. They photograph every license plate that goes by, and they stick all that information in a database that they hold on to for years. They sell that information to other governments and other governmental entities, and the private company who they've contracted with to collect that information also sells all of that information. So, you know, it's one thing to have a system. You could imagine a camera mounted on a squad car, and when the squad car is driving around, it's looking at license plates and checking them in real time to see if there is an Amber Alert or a stolen plate or stolen vehicle, what have you. That's different. That's fine. But when you're just tracking, because it's not keeping that information in a database, right? It's just checking it as it goes by. But when you're gathering all of that information and you're keeping it in a database, the amount of information that you have about each of those people and all the places where they travel over the course of the year is giving away tremendous amounts of information. And the Supreme Court said in a case called Carpenter a couple of years ago that the police cannot put a GPS device on your vehicle without a warrant. Well, this is the same sort of thing. It's just without actually attaching it to your device or attaching the device to your car, they're filming you wherever you go. We think that Carpenter should apply to that situation as well, and keep not just the police, but keep the government from tracking your whereabouts. Facial recognition technology would have the same sorts of concerns with it from our perspective under the Fourth Amendment.
Have y'all been asked to get involved with the vaccine passport issue?
We have not, but I did. You mentioned Pompeo earlier. I saw that he had a comment about that he didn't think that it was a viable strategy. We have taken a look at the issue that the administration seems to be, and I think actually this is left over from the tail end of the last administration, but it has not been changed. And part of being a nonpartisan organization is that we are happy to sue administrations of either party if they are violating civil liberties. But they are starting to require folks overseas who are trying to come back to the United States. Again, these are U.S. citizens trying to return to their home country. We force them to have a COVID test before they can come back to the U.S. I'm not sure that seems to violate the right to travel under the U.S. Constitution. To me, we're taking a look at that issue. We haven't done anything yet, but that's troubling to me.
I think anytime you empower government agents to say, "Show me your papers," that is a troubling, slippery slope that can only lead to ill.
It is not a good phrase in the history of government oppression. That is for sure.
Show me your papers is a sign that you are on the wrong track. We're talking to Mark Chenoweth. We will continue our conversation with him. He was chief of staff to Secretary of State Mike Pompeo, and he is now senior attorney and executive director of New Civil Liberty Alliance. We'll continue that conversation coming up.
The Michael Berry Show continues.
We're talking to Mark Chenoweth, senior attorney and executive director of New Civil Liberty Alliance. He spent some time before this as the chief of staff to Congressman Mike Pompeo, who was our Secretary of State as well. Mark, President Obama, there at the end, his last 2 years, he had lost control of part of Congress, and he said that, well, I still have a pen and a phone. He was going to govern by pen and phone. Well, to the extent that he said that, Joe Biden's actually doing it. Whereas at this point in his presidency, President Trump had signed 15 executive orders. President Biden has signed 34. Why should people care?
I think that people should care about the widespread use of executive orders because it really undermines the constitutional system, right? We're supposed to have, our Constitution makes it very difficult for the government to bind the behavior of citizens. In order to do that, they have to pass a law. That law has to pass both houses of Congress and be signed by the president. That bicameralism and presentment is a deliberately difficult strategy before you can start impinging on people's liberty. And executive orders try to be a shortcut in place of that more cumbersome system that our Constitution put into place. Now, an executive order isn't supposed to and actually cannot lawfully bind citizens. But when you start doing things by executive orders like canceling the Keystone Pipeline or prohibiting federal drilling or requiring people to have testing before they come back to the United States, those things all do affect third parties outside of the executive branch. And even though the executive orders themselves may not be the very thing that is violating somebody's rights, they are setting in motion a series of civil liberties violations that ultimately will have to be challenged probably at the agency level.
On January 6th, Republican attorneys general wrote a letter to Joe Biden raising their concern, saying that he's following the unfortunate path of executive unilateralism. To what extent can the attorney generals be a stop break on that? I know that in Texas, our attorney general, Ken Paxton, has been very aggressive. He immediately challenged Biden's executive orders on ending deportations in Texas. But at some point, it feels like the 14-day stays that he's getting, it's just a delay. You can't completely stop them. To what extent can the attorneys general stop this sort of stuff?
Well, the attorneys general do have power to sue both in their own capacity on behalf of the state of Texas, for example, or they have a parents patria authority to sue on behalf of the citizens of their state. And this isn't an executive order example, but one of the things that came out of the $1.9 trillion, I guess they're calling it a COVID relief package, but a pretty small percentage of that 1.9 trillion is actually COVID related, as far as I can tell. But one of the provisions in that legislation actually prohibits states that receive money from the package from cutting taxes. And that is not something that the federal government is empowered to do under the Constitution. The federal government cannot tell state governments not to cut taxes. That is, you can look as long as you want in the Constitution. You will not find that federal power anywhere in the Constitution. So I would expect, and I would be disappointed if the state attorneys general did not sue the federal government over that aspect of that package, because it's just not a power that the federal government has, and the state attorneys general are really the only people who are well positioned to bring that lawsuit against that law as it is implemented. But there, you mentioned the immigration executive orders. There are other executive orders that the AGs can go after as well, including some of the ones having to do with cost-benefit analysis. Some of the ones having to do with COVID-19, even something like the travel ban is something that I call it the Biden travel ban. This requirement that folks have tests before they come back into the country. I mean, you may have states that have folks who are traveling on state business in and out of the country, and those folks would certainly be subject to that rule, and therefore would have standing to sue. And that's really one of the problems with suing over these executive orders, Michael, is you have to have someone who has standing to sue, which means someone who's directly impacted by the order itself. And that's why I say most of these things are going to not be sued on until they turn into some sort of action by an agency, because that's what's actually going to affect someone in a way that will create standing to sue.
NCLA, the New Civil Liberty Alliance, is supportive of reinvigorating, which conservatives want to do, the non-delegation doctrine. Can you talk a little bit about that and explain it to non-lawyers in the simplest terms you can?
Sure. Well, I think the simplest way to explain it is at the very beginning of the Constitution, Article 1, Section 1 of the Constitution, the very first sentence after the preamble says that all legislative power is vested in a Congress of the United States. And that we call that the vesting clause. And what it means is that all of the power to make law, all of that legislative power is given by the people through the Constitution, is given to Congress. The judges can't write laws. They can't legislate from the bench. The executive branch, whether it's through executive orders or through administrative agencies, they cannot make laws. It's the legislative branch, the Congress, that has that legislative power. What the non-delegation doctrine says is that if Congress tries to pass a law to delegate that lawmaking power to an administrative agency, for example, that act of delegating legislative power is itself a violation of the Constitution, and that any statute that Congress, whereby Congress delegates that power, can be struck down on that basis. Now, that's not to say that federal agencies can't exist or that federal agencies can't pass regulations, but what Congress can't do is turn over wholesale ability to write rules and regulations. Congress has to be the one making the policy decisions. Congress has to be the one exerting control. They can't just tell an agency, you go make the rules, you go decide what to do. And I could give you an example of where I think they've gone too far, if that would be helpful.
Sure, go ahead.
So the Dodd-Frank Act back about 10, 11 years ago now created the CFPB, the Consumer Financial Protection Bureau. And one of the things that they did with the CFPB is they said, you're not going to be funded through congressional appropriations. Instead, we're going to let you be funded through the Federal Reserve. So every quarter, the CFPB just sends a letter over to the Federal Reserve, or the Fed as we call it sometimes, asking for money. And the Fed, from the profits that it makes through the banking regulatory process, takes some of that money and funds the CFPB through that process rather than through the congressional appropriations process. So essentially, Dodd-Frank cut Congress out of the business of overseeing or regulating the CFPB through the appropriations process or even through the oversight process. The Dodd-Frank Act also prohibits the appropriations committees from overseeing the activities at the CFPB. And so we think that's a clear-cut example of where the non-delegation doctrine has been violated. Congress has delegated too much of the power of the purse, too much of its legislative power over to a combination, in this case, of the CFPB and the Fed, and that it can't do that. And that ultimately, when this case gets to the Supreme Court, the court will agree that the CFPB has been delegated legislative power in an unconstitutional way.
Under Richard Nixon, they called it the imperial bureaucracy, and it has only grown since then. Mark Chenoweth, thank you.
Delightful to be with you. Have a great day.